Next, from the mid-year meeting of the Illinois State Bar Association in Chicago, we hear two attorneys discuss the use of social media and its impact on the courts, as well as how technology is making it easier to inform juries as to the facts of a case. We'll also hear how online relationships on such sites as Facebook can create ethical legal issues that have never existed in the past. This runs about 1 hour.
Thank you very much to Judge Shostak, to the ISBA, and to the IJA for having me here to talk. And for those of you who know me and have heard me speak before, you know this is one of the things I love to talk about, courtroom technology. I've been practicing and trying cases for 20 years now. 19 of them I've been using courtroom technology. Of course, it's changed a lot over the last 19 years. But I'm going to spend some time talking about courtroom technology. I'm also going to spend some time talking about social media, and I'm going to take some questions from the audience. So let's start with the courtroom technology. And I know we have both lawyers and judges in the audience, so I think a lot of the things I've tried to incorporate here can get us both thinking about, as lawyers, what does this mean? How would we handle this? How would we do these things in our cases? And as judges, how would I rule on different things as they come up? The first thing, if you're going to use technology, that you need to do is you need to get there early, like I did today, and make sure your technology is working. Because there's nothing worse than counting and relying on technology only to find out you don't have the right cords, they don't have plugs. Gosh, you have an Apple system? We don't have projectors for Apples here. Happens all the time. If you're going to use courtroom technology, you've got to get to the courtroom ahead of time, weeks ahead of time sometimes, and find out, what are you supplying? What am I supplying? What kinds of things do I need to bring? It's very different in Cook County and state court from federal court. Very different here at Cook County than it is up in Winnebago, where they'll rig your courtroom for you. So you need to have a good understanding of how you're going to set it up. Here's just a couple illustrations. This is the federal court system. This is what, if you're going to be trying a case in federal court, it's all set up. The technology is all there. The Northern District of Illinois has beautiful courtrooms, and this is how their courtrooms are set up. So you need to think about ahead of time where you're going to sit, where your witnesses are going to sit, what your distance is, how big your graphics need to be to go across that kind of a distance. This is another courtroom here in Illinois, very different. If you're trying a case and this is what you're doing with your graphics, or this is what you're doing with your graphics, you have to have an understanding of the courtroom and the setup. This one I love because there's so many things to take away from this. As you can see, the jurors in this courtroom, look, they all have a screen in front of them, and the judge has a screen in front of them. And this is the way their courtroom is set up. You cannot possibly go to this courtroom and put a jury in that box and not use courtroom technology. You're going to sit 8 people down in a box in front of a computer screen and not use it? What if your opponent is constantly bringing up graphics and visualization and PowerPoint and list and evidence, and you're there with nothing except maybe a couple boards, blow-ups? Not going to go over real well with your jury. So if this is the type of courtroom that you're going to be trying your case in, you need to know that, and you need to try your case differently. The other thing I like about this particular courtroom is you can see that she's got an evidence cam. If you look at the drawer in the podium, it pulls out, and you can put a piece of evidence down, and it has a camera that projects the evidence right from the drawer cam up onto the screen. Very high tech. But these are the kinds of things we're going to see in courtrooms going forward. And as you can see, this is an 8-person jury courtroom, so this is not even a big case in this jurisdiction, but this is the technology that you're going to be expected to use. What not to do. Technology for technology's sake. When I spoke at Loyola University for Jamie Carey probably about 10 years ago, we did it was for NETA actually, and we had one attorney, Bill Elward, did a closing argument using absolutely no technology, and I did a closing doing an overuse of technology. And we tried to see, okay, how did everybody in the NETA class take away, what was their view on technology as they took away? And the one thing is they said there was too much technology on this side and not enough technology on this side. And useless lists of testimony would be one example. So now this is starting to date myself, but the OJ trial, one of my favorite trials to talk about even still. Remember Cato Caitlin? Well, one of the things that they did in that trial, a lot of mistakes made in that trial. That's a whole nother presentation. But they did a graphic where all they did was set forth his testimony. They just made lists of his testimony and put these up before the jury. Very ineffective. Even as bullet points, very ineffective presentation of evidence. This is a graphic that they used in the OJ trial. Kid you not, this is from the trial. Oh my God, what's my takeaway from this, except I have no idea what this graphic is trying to suggest. Look at all the different colors. Look at all the different fonts. There's multiple keys to marks throughout the evidence. Now, for anybody who remembers the OJ trial or the details of it, tennis court, not even an issue. Never even mentioned in the whole trial. Why was that on there? Swimming pool, not even an issue in the case, but yet it's on there. The whole case had to do with this part of the house right here. Here's Cato's room. This is where the glove was found. This is it. But it's one little teeny piece in this graphic. Up here, poor Mrs. Nebaker, her name never came up in the trial. Who cares that she lived next to OJ? Same thing down here. Salinger's property. Search the transcript, not in there. Why are these on your graphic? It's a perfect example of what you do not want to do with a courtroom graphic. Why are you using this graphic? What are you trying to say? That's the first thing that you need to ask yourself. It should speak for itself. It should be an independent thing that someone can look at it and say, oh, I get what the point of this is. Not happening here. So what are the things you can? Well, let me walk through and show you some basic things to some more extreme things. Photographs. And this has changed. Everybody's had photographs where they actually pass the photographs along. Probably all of you at this point in time have photographs that you've scanned and that you've shown graphically or you've been able to project to a jury. Here's a photograph from a products liability from a car case. But what you can do now is you can zoom in on certain portions of the car and you can blow them up. This was talking about how the column of this particular car, the structural column, failed. And you could see, but even when you're blowing up photographs now, photographs are at such high resolution that you can blow up certain portions of them and still keep them very clear. And that's one thing you want to think about when you're taking photographs for evidentiary purposes. You know ahead of time that you're going to be using those photographs. You want to make sure your investigator, your photographer yourself is taking them at a high enough resolution that you can blow up portions of it and still have the blow-ups in very high resolution. Here's another example from a case where we took, and this brings up an interesting point for judges. This was the actual photograph that we got off Bing.com. Bing.com is a great site for you to get photographs of any particular, maps or photos of any particular place. But for our case, where cars were parked wasn't really relevant. Just like the OJ graphic, why do I want those cars in there? Why do I want people thinking about where people park? I don't. Take them out. Photoshop it. Take them out. Okay? Then you can add things, draw a box and a semi. Those were the only things that were relevant here. This is a very cheap, on-the-fly graphic that you can do. But the question to the judges, and you have to remember, what's your foundational requirement? Yes, this is a photoshopped photo. It's not an actual photo. It's a photo that we got off the internet and then photoshopped. But who cares? If I have a witness who can say this fairly and accurately depicts the location of the garage doors at this factory, at this warehouse, that's all I need. That's my foundation. It doesn't matter that it was photoshopped. This is one of my favorite Photoshop graphics. Now, this was a case that I had where a worker was in this millionaire's house, and when he tried to exit the door, this was a service door, he ended up right off to the right where that rubber mat is, was a double staircase, a very staircase that went down to the basement, and it was extremely steep. The basement wasn't built out. It was 1.5 stories, cement slab. Fell down the stairs and suffered multiple fractions brain injury. And our argument was the way that this door was designed and the way it opens, you have to step to the right to get out that door. And by stepping to the right, just enough to get out that door, he lost his balance and fell backwards and went down the stairs. So It was a design case, and falling down the stairs is a hard case in Illinois under Illinois law. But so we had an architect, and we were talking about the architectural design. So this is how the door existed. And one of the defenses was, well, that's the only real way to have the door, because you want a door to open against the wall. That makes sense. So we photoshopped it. We just took the door and we flipped it. And we showed, this is actually a much better design if you really think about it. It opens fine. It doesn't matter that it doesn't abut against a wall. And look at that, it blocks the staircase, and you would step to the left to go around it. So this was photoshopped, but our expert was able to say, well, this fairly and accurately depicts an alternative method by which this door could have been placed. And that was the foundation that we needed. The other thing we did with this exact same photo, so this is where we start, is we changed the lighting in it. Because when he left, it was evening. Even this looks a little light, like, well, it's pretty light. There's a lot of light coming through a glass door. You should have seen that there was a staircase right there. But when we made it darker, not so easy to see. And again, yes, it's photoshopped, but we sat with the trial witness ahead of time, and we changed it from light, dark, 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 shaded, shaded, shaded. Now you tell me, my trial witness, when the lighting now is accurately depicted at the time that your coworker fell down the stairs. So we went darker, 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 darker. He said, yeah, that's about it. It was about dusk. That was about the lighting. Boom. Okay, we saved it, and that was the photograph that we used. And the witness was willing to say that fairly and accurately depicts the lighting conditions at the time we left the building that night, and that's sufficient foundation. Timelines. Timelines have definitely come a long way in graphics, and probably everybody has used a timeline. They're so effective, no matter whether you're talking about a short period of time or a long period of time. Timelines are so easy to do with PowerPoint. If you're interested in PowerPoint, you want to try and do it yourself, there's a great book that's put out by NITA called PowerPoint for Litigators. I think it's in its 3rd volume right now. It comes with a disc at the back of the book that you just pop right into your disk drive, and it will teach you and walk you through making just about any PowerPoint item that you want. So you put in your disk, and it will have a bullet for timelines. You can go right on your disk to timelines, and it will help you enter the data. You can do it yourself. If you think you can't do it yourself, then just look around your office or your home, pick the youngest person in your presence, and give it to them. They'll be able to do it. So here's a timeline that's kind of changed over time. Yes, it's very basic. This was a case where we had an EMT that went out to a house at 5:53 in response to a child that was having an asthmatic attack. They were there for 20 minutes. They left at 6:22, which was 29 minutes later. They got a second call. The child was in respiratory arrest and ended up dying. And so we were using the dispatch reports to show, well, you were there for 20 minutes, because they said, well, we just stopped and the mother waved us off. She didn't want us to see the child. We didn't do anything. And we can't be held responsible because we didn't initiate any treatment. And so we wanted to show, well, you were there for 20 minutes. You were in the house for 20 minutes. And it was 9 minutes later that the child has respiratory arrest. What were you doing in the house for 20 minutes? A wave off seems like it wouldn't take very long. So we had this graphic that we prepared, and we did it with hyperlinks. And what hyperlinks are connections from your graphic to your supporting evidence or your supporting documents. So everywhere that I have, let me just switch. See, this is an arrow. If I put it on any one thing here, it turns into a hand. And that means I have a hyperlink. So I can put the EMT on the stand and say, now you were originally dispatched at 5:53. Well, I don't remember what time it was. Okay. Well, let's go to your report. Okay, look with me at your report. Do you see this? Dispatch 17:53. That would be 5:53 in the evening, right? Okay, and then we go back to the home. Now, the second time you were dispatched, 6:22. Again, I can hyperlink that to the document. So it's a very quick way of getting your witness to follow along with what you want them to say, rather than, all right, let me show you what I've marked as exhibit number 1. Do you recognize this document? Is this the EMT report that you prepared? Can you look in the right-hand corner where it says a dispatch time? The jury's just sitting there going, oh my God, we don't see it, we don't know what you're talking about, we're zoning out, I'm working on my grocery list now. This keeps your jury very engaged, and it's much faster through the foundational things that you need for the data points on your graphic. So hyperlinks are a great thing to use in your courtroom technology. These were the testimony of the paramedics. It was the same thing. If anybody disputed with me that they were there for 20 minutes, I had in their depositions exactly where I got the 20 minutes from. And I was able to bring up the questions and the answers, and then again, always have a hyperlink back to the home. Okay? Medical illustrations and images. I know when I speak at different seminars, everybody in the room tries very different cases. Big cases, small cases, plaintiffs, defense. We have judges here now that are thinking about how they're going to rule on different things. And I, too, over the last 20 years, have tried a lot of different cases. Some of the cases, for whatever reason, I'm spending tens of thousands of dollars in graphics and courtroom technology. Some of the cases, I'm having a legal assistant do it in the office the night before, or I'm working on a very low budget. And that's one of the great things about courtroom technology and graphics. It can be a fraction of the price on what you spend on those boards and the blow-ups. When I walk through court security, I'm usually carrying a laptop and a projector and some cables, and that's it. And then I see lawyers that are coming through with their dollies and 20 boards and struggling through. And then we get to court, and oh God, the judge is redacting it. So now they're putting white tape in the middle of their boards and blocking out that there's insurance or that there's a problem with this. I can just type it and make changes. But these illustrations, a couple of these I really like because it shows how easy it can be. Now this was a handicapped boy that I represented, clocked by a car in a crosswalk as he was going across the street, broke both of his legs. It's a $100,000 policy. They won't pay it. It's a perfect bad faith case, but first I have to try the case and I have to win the case. So it's a $100,000 policy. My boy has horrific injuries. I'm not spending a lot of money on graphics, but I'm damn sure going to win the case and get as high of a verdict for him as I can. So this is right out of a textbook. I got this page, I labeled it, I scanned it, showed it to my expert, showed it to his treating physician. I didn't have an expert. Yeah, this basically shows a comminuted fracture of the tibia and the fibia. Yes, again, right out of a textbook, this is what we do when we fix it. This is what his treating physician used. This is his actual x-ray, which I had Kinko's put on a disc for me and was able to show the actual x-ray, and that this nailing ended up with this permanent bar in both of his lower legs. Again, very inexpensive. Less than $10 to have that done by Kinko's, scan an x-ray and put it on a disc. Medical records, probably most of you are doing this if you've had a case, but you can do this with any type of a record. It's just not a medical record. But medical records are a good example because they're so hard to read. And hopefully by the time you're trying a case, you've figured out what the notes are. There's only a few that are relevant or important. But in any business document, it's nice to, rather than giving the jury this document in a book, an exhibit book, maybe that's a better way to do it, or on a big board, just blow up portions of it and then type it out. As long as you're sure that that's what your witness is going to say it read, much easier. You just want the jury to focus on the parts of it that are relevant. I'm going to skip through these. Medical literature, easy to pull out different parts. Maps, okay. Now, here's one for the judges. I know that there are a lot of judges who want the attorneys to show everything they have before they start the trial. Graphics, exhibits, everything. Show it to both sides. And I agree, there's some benefit to doing that. But in today's use of courtroom technology, the lawyers have to be given flexibility to do things on the fly. Things change, evidence changes, witness testimony changes. You cannot contemplate every graphic that you will need before you start a trial, nor should you be handcuffed from doing that. It's so important to be able to change and modify based on what's happening. And this is a perfect example. This case we tried against the CTA. It was a 13-year-old boy. This was 20 years ago, 19 years ago, before everybody knew that there's electricity in the third rail. The 13-year-old boy was on the platform of the CTA. As 13-year-old boys, I have a 13-year-old boy, sometimes they just need to pee. He walked down the platform, it was night, his father's a Chicago cop, he went somewhere private, went to the end of the platform, made sure nobody else was there, and he peed on the third rail. The electricity went up through the urine stream into his body, he was electrocuted, and he was killed. We brought the case against the CTA, it went up to the appellate court, it came back down, we had to retry it. One of the main issues in the case was notice, whether the CTA was on notice that this type of thing was happening, whether there should be warning signs about the electricity in the third rail, which there are now. We call them the Taylor signs, based on this little boy Taylor issue. But there weren't at that point in time. And a CTA rep was on the stand, and we had a list, a 20-page summary of all the deaths on the CTA-L for the last 10 years. Vast majority of them were suicides. Vast majority of them were intoxication, drug-related. Not as many were electrocution. At least when you looked at a list of hundreds of accidents on the CTA rails, that's how it appeared. But when you really looked at it, there were a lot of electrocutions. It actually seemed like kind of a big deal. But the CTA rep on the stand was not willing to admit. He said, well, yeah, I mean, it happens, I guess it happens, but not a lot. We're really more concerned with people getting on the tracks. That's why we have fencing, with suicides, things that we can't prevent, or doing things that we can prevent. And we couldn't believe that we just couldn't get him to admit that electrocution was a problem. So we took a lunch break, sent the legal assistant to the CTA train station, and we got this map, and we scanned it, and we brought it back on the computer over the lunch break. And when we continued with the cross-examination of the CTA rep that was on the stand, we had him flip through that 20-page report, and we said, now just tell us the location of the electrocutions that have taken place. This is totally on the fly. If we had been required to do our graphics ahead of time and to present them to the other side, we never would have been able to do this. So slowly but surely, he went through and he said, all right, well, let's see, the first one here was on the red line up near Evanston. And so we put this red arrow. About here, is that the station that you're talking about? Yes, and our legal assistant did it. Okay, go to the next one. And that was a death. We only did electrocutions and we only did death. And as we went through the addresses and as we went through putting on the red arrows, it was like a moratorium. It was dead silence in the courtroom. And by the end, this is what our graphic looked like. It was a little hard for the CTA to argue that they didn't have notice that people were being electrocuted on the rails. Again, I bring this up as it's one of my favorite graphics. It's a fabulous case. It's a fabulous story as to what happened, but it's so important to be able to change your graphics as the evidence goes in and as things change. Okay, I'm already down to 5 minutes. All right, graphics that persuade. Let me show you this one and then we'll stop. We'll switch to social media. This is another one of my favorite ones. This is labor and delivery case, which is mostly what I do now. This was a chart right out of this was a page right out of this woman's medical chart. And it was very telling, very compelling, but it doesn't look like that based on what you're seeing right here. Again, your graphic needs to tell a story. This doesn't really tell very much. So I took this and I focused in on the curves on the bottom. Okay? And what this is this is how a mom's labor is supposed to progress over time and with cervical dilatation. And this is what happens in a first delivery. Again, this is their record as to what you should expect, what the nurses are looking for. You want labor to follow these labor curves. And if it's a second baby, then things move along a little faster. So labeled those, added some color, cleared it up, and we decided to plot this mom's labor. So we took down at the bottom, where was she at 1900? 3 centimeters dilated, okay. And then there she is, that's 1900 on the bottom, 3 centimeters dilated. All right, so she's not exactly on the curve, but she's in between them, and it's following the right pattern, so things are looking good. Her labor should be progressing, the nurses should be following her. So now she's 7 centimeters dilated. Okay, she should continue to go right up to 10 and then push that baby out. This is what you would expect to happen. but she flattened out, okay? Labor's not continuing to progress. She's outside the curve, which should make the doctors and nurses think, what's going on here? All right, so that was, each block is an hour. That was 1, 2, 3.5 hours later, and she's flattened out. Probably a good time to get the OB in to see what's going on. But they didn't do that. They continued to let her labor, and now she's actually going the opposite direction. That's an hour and a half more time. Wow. Now we really need to intervene. We really need to get this baby out. Things are not going well. But did they get it? No. Okay, she starts to go back up. They gave her Pitocin, they gave her meds, they tried to get things going. Another hour, 15 minutes. Another hour, now she's completely flat. Another hour, nothing. Another 2 hours, no OB present. And that was finally at the time that they did an emergency C-section, and the baby was born with severe cerebral palsy from lack of oxygen for at least 7 hours. That was right out of their medical records. Very hard to argue with, well, it doesn't always go that way. Well, gosh, that's your medical records. That's your curve. That's what we used. This is what you were supposed to be plotting on and watching. So those are some examples of graphics that we've used. I'm going to switch and talk about, let's just see if there's anything here we should definitely look at. Jury instructions. This is an easy one. I think almost all judges now will let you emphasize certain jury instructions over others. Even graphically, you can use them. We'll bring them up, the ones that we want. 1501 is always a big one for the plaintiff's lawyers. And we'll even highlight the portions of it that we want to emphasize and talk about and want the jury to focus in. And I think most judges have let us do that and emphasize certain jury instructions over others. So let me just switch and let's talk about social media for a few minutes. If I knew that you were going to be tweeting while I was standing up here, I would have had your tweets running along the bottom so we could see what your comments were and how this was going along like they do on The Bachelor and The Bachelorette shows. But I decided 2013 was going to be my year of experimentation with social media. As of December 2012, I was not on social media. I did not have Facebook, I did not have LinkedIn, I did not tweet, I had no accounts. And then I hired a consultant, he's also one of my best friends, and I said, build me up, make me socially media active. And she did. She built me a Twitter account, a Facebook account, and a LinkedIn account. And I said, I'll commit for a year. I'll do it, I'll post, I'll blog, I'll tweet, and we'll see how it goes. We'll see how it feels for me. We'll see how it works for my business, for marketing, for speaking, for client contact and communications. And now, at just about the end of 2013, I can tell you it's been a huge success. I've enjoyed it thoroughly. It's been wonderful for my marketing, for my presence, which is important as a plaintiff's lawyer. And I think Don Tracy can probably account for this. My husband, who's not a lawyer and is a salesman, every week someone comes up to my husband and says, did your wife just become a lawyer? Did your wife switch firms? Isn't she your wife? Every week he's going, oh my God, what did you tweet about? What are you twittering about? But if you go on to any of my sites, it will tell you a lot about me and what my interests are and what's important to me. I blog a lot about child obesity, nutrition, education, vaccines, recalled medications. I blog a lot about, I do tainted steroid cases from NECC. I talk about compounding pharmacies, FDA regulations. It might not always be about cases that I have or what I'm doing, but it tells you a lot about who I am as a person and the things that interest me and the things that are important to me. I also retweet things from certain politicians that I like and that I believe in. You can certainly guess based on my LinkedIn page that I'm a Democrat, that I'm involved in Illinois politics, that I like that crazy senator from Wisconsin. So you can, just from going on my social media professional sites, you can learn a lot about me. The question is, what does that mean to you as a lawyer when you're thinking about jurors and voir dire, and once you have jurors impaneled? And I really raise these issues more as things for you to think about as lawyers and also judges to prepare yourself for ruling on. I'll give you an example. 20 years ago, when I was a baby lawyer and trying one of my first cases with Lorna Probst, there was a man in the voir dire panel who raised his hand, said he couldn't be fair. We went in the back room and I said, why can't you be fair? And he said, well, I don't want to sit here and listen to her try a case all week. I want to date her. Okay, well, that's a little embarrassing for me in front of the judge and my senior partner, and not really sure what I want to do except excuse that juror, which the other side agreed to. Well, now that wouldn't happen. He would just tweet me later that day. Or he would send me a little note on Facebook, or he would go on my LinkedIn page. There would be contact in some other way other than having to just put it right out there and say that, because that's the way people communicate now. They don't talk anymore. They don't have those types of conversations. It's all social media. So what do you think about this situation? Here in Illinois, we usually don't get jury cards and information about potential jurors ahead of time. A lot of other states, they do. They might have those cards for 2 weeks, and you can get into investigation of your jurors. You can get on their social media sites. You can see who their friends are. You can see what they're posting about, what they're blogging about, what they're liking, who they're friending. You could do that. But here in Illinois, at least in most jurisdictions, you're getting your juror cards on the day you're picking them as jurors, or maybe the day before if your jury selection's going long. By the time your window to get in a person's social media site starts to tick, they're not voir dire members, they're your jurors. So what are you going to do? When you have a juror impaneled, are you now going to start going into their social media sites? Are you now going to start investigating into what's important to them? What are they liking? What are they disliking? Are they starting to change their posts? Are they posting anything about the judicial system? Are they posting anything about jury? Are they posting anything about cerebral palsy when you're in the middle of a birth injury case? Are they retweeting anything that you've tweeted? Most of you are probably on LinkedIn, and I'm going to talk about LinkedIn because I think most of you are probably familiar with LinkedIn. It's a very professional, it's what it's geared towards, professional networking. Okay, so let's say you're on LinkedIn, and we'll use Jessica as an example. Let's say Jessica is on LinkedIn, and she decides that she's going to take on jury trial day 3, she's going to go into her LinkedIn account. And she looks, and she gets a report on who's been in her LinkedIn account. And she sees that Wendy, who's one of her jurors, was in her LinkedIn profile. She gets notified that this person has viewed her profile, because you do in LinkedIn. You get a weekly report on who has gone, there's a footprint, and viewed your profile. So now Jessica knows that one of the jurors, Wendy, has gone into her social media and seen her. Does she have to tell anyone that? Does Jessica, the lawyer, have to let anyone know that one of the jurors has been looking into her and reading stuff about her? What about if Wendy didn't leave a comment, but just left a footprint that she had been there? Okay? So let's say Jessica doesn't do anything. She doesn't bring it to the other side's attention. She doesn't bring it to the judge's attention. And maybe Wendy's going to talk about whether she has to or not. Let's say the next day, Wendy goes into the lawyer's, Jessica's LinkedIn page, but now she likes a couple of Jessica's posts. She likes a post about Johns Hopkins doing more research into cerebral palsy. She likes that Exelon is giving money to children with handicaps. She likes things that, boy, this is boding well for my case. She's really showing that she's interested in CP. She's interested in children getting support for CP. She's educating herself on what services CP children need. Does Jessica have to tell the judge that? Now the juror has been in her LinkedIn and has liked some of her stuff. Okay? So what if we bring Wendy in as the potential juror and question her? And she says, well, the only reason I did is she was on my LinkedIn profile. And Jessica has to say, well, I was. I did go into all my jurors' LinkedIn profiles. I did. I was checking in their social media sites. And yes, Wendy, Jessica, the lawyer, is the one that started it. And the juror was able to see she was in my social media. Why can she go in my social media and I can't go in her social media? These are cans of worms that we open. And it's what I ask you to think about. My practice is I don't go into it. I don't open that can of worms. When I get juror cards, I don't go into their social media sites. When jurors start to give me problems during the trial, or they start to make me worried, or I don't like the way they're looking at me, I don't start investigating them to see what they like, what they dislike. Are they blogging about me? Are they tweeting about me? I don't want to know, because if I find out it's bad for me, it messes with my head and there's nothing I can do. If I find out it's good for me, I have to tell the judge, and now I'm losing one of my best jurors. It's a no-win situation. So my suggestion is leave it alone. If you're in a jurisdiction where you have a window of time where you can investigate your potential jurors, and you want to go into their social media sites and do a full-blown investigation into your voir dire panel, God love you, go for it. But once they're your jurors, hands off. Any questions? The question was, should we have judges advising the jurors at the beginning of a trial, look, I don't want you going into this, contacting the lawyers, going to social media, blogging. And yes, I'm on the IPI Jury Instruction Committee, and we changed 101, the cautionary instruction, and there's now a provision where the judge specifically talks about you are not allowed to go onto the internet, use social media, use any of these sites to do your own investigation into this case. And then there's an optional section where the judge can remind the jurors throughout the case, let me remind you, you are not supposed to be using any internet services, any drives, any social media to do your own investigation in this case. I can tell my 12-year-old son to stay off his iPod all night long. It ain't happening. It's in his hand. He can't help himself. He'll be on it. Your jurors will be on it. They can't help themselves. No matter how much you want them to, you have to face the facts that the times have changed. It's in their pocket. It's in their hand. You say a word they don't understand, they're looking it up in Wikipedia before you've even finished your sentence. It's just what they do. I don't think it can be controlled, but we try to. But we also give instructions that you're not to have any contact with the lawyers aren't to have any contact with you, they're not being rude, they're just not allowed to. So, okay, the jury heard that, but then they also find out that you were in their Facebook, you were in their Twitter. You know, these kids can find out everything. I don't know if there's footprints in Facebook yet when you go into somebody's Facebook, like there is in LinkedIn and there is in Twitter, but I bet there's a way. So I just don't know if there's enough cautionary instructions that can be given to change it. Certainly something to think about. But I don't want to be the one starting the process, starting the ball rolling. Questions? Comments? Okay. I think that happens all the time. You know, I think what the conversations that happen in a jury room, usually we don't know about, but I think there's a lot of times where jurors are doing outside investigation and it's never brought to the lawyer's attention or the judge's attention. The only time I've really had a situation is where a fellow juror ratted you out. You know a little too much in the jury room, or you brought in some of your printouts from up to date and tried to educate your fellow jurors, and then there's an investigation and it's a question of whether there's a mistrial. And it's a difficult situation for the judges then. How much are you going to put that juror on the spot? Are you going to leave them in? Are you going to take them out? How does that affect the trial? Can you go on without them? Can you swap in an alternate? In the one case that we had that come up, that's what we did. We questioned that potential juror who had materials that they had investigated themselves. We found out exactly what he had told his fellow jurors, how much he had delved outside the facts of the courtroom, what he had educated them about. We had him removed, had an alternate swapped in, and decided it was best to keep going. Everybody was in agreement on doing that, and that's the way we handled it. Now, the judge told that juror that he was to report to him on a certain date, and it was a date that the trial would be over, and the judge was going to have a talking with that juror. I don't know whatever became of it. I didn't follow up on it, didn't think it was my place to. But I think the judge was interested in making sure he understood that he could be held in contempt of court, and there were repercussions for not following the judge's orders.
Is the contempt of court discussing what you find on the internet with the other jurors, or is the contempt of court looking at the material?
It's looking at, it's under the new instructions that the jurors are given, it's looking. It's looking. You're specifically instructed not to do your own investigation, that it's not fair to the attorneys. You have to decide based on what you hear in this courtroom. So just taking the steps of educating yourself and putting knowledge in your head that you did not have before the trial and nobody knows that you're getting is the violation. I don't know if that actually constitutes contempt of court or if a judge has the strength. Maybe Wendy does.
There's actually an interesting, I don't know what happens with a juror, Judge, I assume, but there's a California case where a lawyer actually served on a jury and was blogging in contravention of the instructions. And he said, well, no one told me not to blog, but there's actually specific procedural rules in place. So he was blogging and he was disciplined actually for that conduct. You know, it's a good question. I don't know if he was held in contempt of court, but if you want to contact me at my office, I can easily get you that information on that case. Okay?
Thank you.
So I confess that about a month ago when I was looking at this program and the description of the program, it said somewhere, equip yourself with the information needed to incorporate technology into your practice. And I looked at my paralegal and I said, will you find out, is that what I'm supposed to be talking about? Because I don't have a social media presence yet. And my great story about social media presence is when my now 19-year-old was in high school, he used to tell me, Mom, cool moms don't have Facebook pages. We all know why he said that. Now that he's in college, he keeps telling me, Mom, you need a Facebook page so I can friend you. The truth is, if I could find a way to have a Facebook page and be somewhat anonymous, I would, but Beth sort of has inspired me, so I may make 2014 my year of social media. As for asking the youngest person in the audience, I used to think that's true until my 80-year-old mother became a technology genius, and I can just go ask her for help. So what is social media? We've talked about that, but I want to tell you from the standpoint of a bar regulator. On Facebook, your friend is not your friend. Delete is not delete, and private is not private. There's your Twitter like. Here are all the different things that are social media. Some of them I have heard of, some of them I'm completely unfamiliar with. And here is a helpful diagram on social media explained. And so you can see it's Facebook, I like coffee, Twitter, I'm drinking coffee, LinkedIn, I'm good at coffee. And what I'm going to try to do is I think I have, just so that you get your credits, I have till 10:30, but so I'm going to go through some of these first slides a little quickly. Believe it or not, there are over 1 billion Facebook users, there are over 1 million active Facebook users, and there are 1 billion LinkedIn endorsements. Now, again, from my standpoint as a lawyer regulator, things that go together: peanut butter and jelly, Oreos and milk, things that do not go together, the internet and privacy. So it is, the other way that I'm going to ask you to think about it is E is for electronic, eternal, and evidence. One of the things that we are seeing is a surge in cases involving issues with social media and lawyers. Where do we see the problems occurring? Confidentiality, so lawyers forgetting that what they do on the internet, they cannot put confidential client information on the internet. Seems somewhat obvious as I'm standing here talking to you, but apparently it's not as obvious as we think it is. We see issues with candor, lawyers doing things that under the rules you couldn't do by hiding behind either an alias or a fake identity on Facebook, or having someone else do what you yourself as a lawyer couldn't do. Remember 4.2, you can't have, which is contact with a represented person. You can't have someone else do what you couldn't do, and yourself. And even though it's no longer in the rule, it's in the comments now. And then the other problem that we're seeing on social media is somewhat obvious, contact with represented persons, but it's how it happens that's of concern. So one case, recent case from Georgia, a 1.6, which is the confidentiality rule. Remember, the new confidentiality rule is all information relating to the representation is confidential. And if I was going to give you a helpful Venn diagram, I would say the big circle is confidential information. The little circle inside that big circle is attorney-client privilege. And then intersecting with attorney-client privilege is work product. But confidential information, all information relating to the representation, regardless of the source, unless disclosure is permitted or required by an exception or is impliedly authorized. So Beth is obviously completely entitled to discuss her client's medical condition in a personal injury case, because that's what she's hired for. She doesn't need special permission. But you have to be so careful when disclosing confidential information, because the case law even says just because it's public in a courtroom does not mean it's public. So what do we have? This case from Georgia. Client hires lawyer, fires lawyer, goes on consumer websites, posts negative reviews of the lawyer. What does the lawyer do? Goes on a public website and posts confidential information, meaning information she learned in the course of representing that client on a public website. The Georgia bar had stipulated to a reprimand of this lawyer. The Supreme Court rejected the petition and said, no, a reprimand is not a severe enough sanction for a lawyer who violated one of the most fundamental obligations of the profession, that is, posting on a public website confidential client information. They remanded the case for further information because they said that it was a consent decree, what we would call in Illinois a petition for discipline on consent. They said there wasn't enough information in the proposed consent decree about what information the lawyer had actually revealed on the public website. And in their rejection of this consent decree in Georgia, they cited to the Illinois case from a number of years ago. I think it was one of the first national cases where we had a very well-respected public defender from the Rockford area blogging on a public, non-password protected website about confidential client information. My client, jail number 12345, is so dumb that he appeared before the judge and told the judge that he was drug-free when he was still taking methadone. And then she also failed to correct the information once she knew that her client had advised the judge of false information. So she got a 60-day suspension, and then they cite to an Oregon case with a 90-day suspension. So what crazy things do we see happening? And actually, this is straight off this young lawyer's, I found it on the internet, as a matter of fact. So Wednesday of this week, the Kansas Supreme Court denied in 5 days the petition for rehearing of former Attorney General Phil Klein, who was indefinitely suspended for ethics violations relating to investigations, grand jury investigations that he conducted about Planned Parenthood and abortion clinics. It was a highly politically charged case. And I will try to leave my politics out of it only because of where I work, but you may very easily be able to figure them out as I go on with this presentation, no matter how hard I try. But in any event, it was a really politically charged case. There was pro-lifers, there were abortion proponents on both sides, and when the court denied his motion for rehearing in 5 days, that was considered political too, and you can find articles if you go on the internet of people saying, gee, for a Supreme Court that takes years to rule on a motion for rehearing, this certainly shows that they are biased against my client, Mr. Klein, because they didn't even seriously consider this motion. How can they consider it in 5 days when usually it takes them years to do it? So what started a problem in this case? Among the fact that it was already a politically charged situation, we have Sarah Peterson Herr. She is a clerk at the time for the Supreme Court. The court is hearing the discipline case on Phil Klein's disciplinary proceedings. And she tweets during the argument and excuse me, but this is the exact quote from her tweet, "Why is Phil Klein smiling? There is nothing to smile about, D-bag." You can see it. She spelled the word wrong. She also spelled Mr. Klein's name wrong. She tweeted immediately after that, "Mr. Klein will be disbarred in the next 7 years for his conduct." Okay? This is not just dumb. This causes a clear problem because it seems then that she's tweeting something about what the judiciary is thinking about or discussing in the case, and it caused a huge problem. She was rightfully fired the next day, and it caused a problem because Mr. Klein's lawyer then asked for an independent investigation of the judiciary, alleging that the judiciary was biased because their own law clerk is tweeting in the middle of an argument. Sometimes, some of these cases are hard to believe. Rachel Alexander. Ms. Alexander's former boss is the now disgraced former county attorney of Maricopa County, who was disbarred for perjury, filing malicious and bogus criminal cases against his political enemies, which included judges, lawyers, and others. On the internet, you can actually find some incredibly compelling testimony from the Thomas disciplinary hearing, which, although he was in Arizona, they brought in the head of the Colorado agency to try because the people in the Arizona Bar Council's office were getting death threats after they charged Thomas in the disciplinary proceeding. John Gleason, former director of Colorado, former detective, actually went to Arizona to try this case, and he had FBI protection during the trial. His wife was actually stalked at the pool during this case. So sometimes our work is dangerous. In any event, Rachel Alexander, was allegedly Mr. Thomas's stooge, and Thomas's buddy, by the way, is Sheriff Joe Arpaio, who's still in power in Maricopa County. And Rachel was allegedly his stooge, and she filed a bunch of completely frivolous RICO cases against the judges and other political enemies of Thomas, and she was disbarred along with Thomas. So if you go online, she is now reduced to begging for cash for surgery for her kitten. She has a blog post now where she discusses things like, had she been aware of all pertinent information, the case might have proceeded differently. The hearing board said this is a far cry from a sincere expression of remorse. She called the case against her a trumped-up, meritless witch hunt, unfairly targeting her for her conservative views. So what about counseling clients on social medias? What are we seeing in this area? We are seeing spoliation, and actually this case I think might be of interest to the judges as well. This was a case out of Virginia, and we first learned about it because there was a sanction order entered by the judge. And this sanction order gave information that included this lawyer, Michael Murray on the left, and his client with the I Love Hot Moms t-shirt were sanctioned by the judge after a quite successful jury verdict to the tune of about $700,000. Most of it was against the lawyer, a small portion against the client. Why? Because during a wrongful death case, that client had a picture of himself with the I Love Hot Mom t-shirt on, I Heart Hot Moms, surrounded by multiple apparently attractive women, and the lawyer told his paralegal in the middle of the case, we got to lose this picture, because if this comes out in the jury trial, this could really hurt us. So the paralegal does just that, instructs her client, their client, to take that picture down while there are pending discovery requests. Client then appears for a deposition and says, Well, as of the date of this deposition, I don't have a Facebook page. And they also answered a production request saying, as of the date of this production request, don't have a Facebook page. And I don't think the answers were quite so blatantly obvious, because if you hear someone say, well, as of the date of this deposition, I don't have a Facebook page, clearly the next question is, did you ever have a Facebook page? But so that resulted in sanctions after the jury trial. Now the lawyer's been suspended and the facts came out. It started with defendant's request for production of documents. The lawyer asks his paralegal to look at the client's Facebook page. She looks at the Facebook page. They send Isaiah, that's their client, emails, and they tell him, you may have something on your head and are holding a bud with your I Love Hot Mom t-shirts on. There are two couples in the background. Both girls have long blonde hair. Do you know that picture? There are some other pictures that should be deleted. And it's in emails. Like I said, E is for eternal and evidence. Murray instructs Isaiah to deactivate his Facebook page after these emails. On April 15th, Murray's response to the defense was that Isaiah did not have a Facebook page. This is when a day before he tells him deactivate it. Court orders Murray in November to produce a privilege log. Court orders Murray to file an amended privilege log. In December, Murray notifies the court that my assistant overlooked an email from March 26, the one about deleting the pictures. Court sanctions Murray, there you go, $542,000 for Murray to pay, and Isaiah remits $180,000 to the defendant. Murray entered agreed disposition in his disciplinary case, where he was suspended, I think, for 3 years. I lied, 5 years. It helps if you know the next part of your timeline. What about privacy in a network setting? Here, a lawyer, yes, I see a question.
What if, in that case, the Murray case, the lawyer had preserved all the evidence from the Facebook page and then delivered it to the other side, but at the same time heavily instructed the client to deactivate the Facebook account? Would there have been a problem?
I think the whole problem in this case was the lack of candor. So I think if the lawyer instructs the client to deactivate the Facebook page and they're clear that he had a Facebook page until this date and the evidence was delivered, I don't think it's a discipline case. I don't know what would happen in the discovery issues in the case itself, but some of these cases become discipline cases only because of the lack of candor. So it's the lies. I always say the cover-up is worse than the crime. So really, if the lawyer decided that his client had such bad judgment that it's better if he just doesn't have a Facebook page, and then they produce everything prior to April 14th, and then they say on April 14th I deactivated my Facebook page, and they're honest about it, I don't see that as a problem. I don't know what the defense would say in the case, but I think the lack of honesty in this case caused both the sanction and the 5-year suspension order. I'm going to go ahead to a couple things. So here's another case with lack of candor, phony emails. So this lawyer is a patent IP practitioner, worked for a firm where a summer associate was employed. Apparently, he decided that he really wanted to date her, and she rejected his advances. He was so offended that she rejected his advances that then he, or maybe obsessed with her, I don't know which, that he then started looking up information about her online. He discovered that before going to law school, or while she was in law school, in order to make a little money, this summer associate had starred in some horror movies. And in a couple of the horror movies, there were topless scenes. Unbeknownst to Mr. Usher, the topless scenes, the lawyer, now lawyer, had a body double serve in her place. What he does is then creates a bogus email account that appears that it's coming from a named partner at the firm, and he basically accuses her of being a slut, excuse my French, but that's like the quickest way to summarize the email. And he says that no one should use a firm, because she's now with a competitor firm, that has this idiot who bears her breasts in movies, etc., working for them. Well, it turns out that the summer associate, now lawyer, finds out about these things, and the lawyer was disciplined. Why? Again, we're looking at the dishonest conduct. His defense was it was his First Amendment right to to say whatever he wanted about this girl and her horror movies on the internet. The problem is creation of a fake email account, and also the information was not true. He was disciplined for his conduct involving dishonesty and conduct prejudicial to the administration of justice. Other candor issues. So as a lawyer, we all know that we have obligations to investigate evidence. Just because our client brings us something and says, well, here, I got this keychain drive, you can't necessarily use this keychain drive. This case out of Florida involved lawyers getting a keychain drive under, quote, very, very suspicious circumstances. The lawyers spend hours, hundreds of hours, reviewing the keychain drives, and they obtained an improper informational and tactical advantage because it had financial information about the husband to which they might not otherwise have been entitled. They certainly weren't entitled to it the way they got it. The firm was disqualified in this case, and they were told that they'd be wise to have their client consult with a criminal defense lawyer. The issue in that case was where a lawyer knows that a client got information wrongfully obtained, the lawyer is ethically obligated to advise the client that materials can't be retained or reviewed by the lawyer without first informing the opposing party and the attorney. Consistent with our understanding of the rules here, if you get something that is privileged or that you believe is improperly obtained, what do you have to do? The first thing you have to do is notify the opposing party that you have it. It is not necessary, whether or not all the comments and the precedent says whether or not privilege has been waived by how you get it, for example, if it's a discovery production, is an issue outside the scope of the rules, but the first thing you have to do is at least notify the other side. Other candor issues on Facebook, we had a lawyer asking a judge for a continuance, then ended up and the basis for the continuance was that the lawyer had a death in the family. The lawyer forgot that the judge and the lawyer were Facebook friends. And the judge found pictures on the lawyer's Facebook site of the lawyer dirt biking all weekend. Well, so someone in an audience once said, well, maybe she didn't like the relative too much, so she went to the funeral and then she dirt biked. But apparently the lawyer's Facebook page was full of not just dirt biking competitions, information about all the margaritas the lawyer had drank at the parties that she attended that weekend. So that brings me to another issue which is not addressed in the PowerPoint, but the question is, can judges and lawyers be friends on Facebook? There are opinions in many jurisdictions, not Illinois. There's Kentucky, South Carolina, I could name them all, New York, Ohio. The interesting thing is they actually are all over the place. So some say, yes, you can under certain circumstances. Some say it's a bad idea because it creates an appearance of impropriety. So I don't know how many of the judges in the audience have a Facebook presence, but if there's a lawyer appearing in front of you who's your friend on your Facebook account, at the very least, I think a wise course of action is certainly not to have communications during a trial. There's actually some discipline cases on that where a judge is Facebooking a lawyer in the middle of a trial about his opinion of a witness's credibility. Bad idea, seems kind of obvious. But Illinois does not yet have an ethics opinion on it. I'm going to go to some of our problems with contact with represented parties. Remember what I said about 4.2. You cannot do on Facebook or have someone else do what you couldn't do yourself. This is a case out of New Jersey where these two lawyers represented the defendants in a personal injury matter. They told their paralegal to friend the plaintiff on Facebook and access information available to the public. The plaintiff did it the paralegal did it without identifying who she actually was. And then the defense got access to photographs and other information about the plaintiff, which they attempted to use to show that the plaintiff was not injured as badly as she claimed. Now, this might be an appropriate tactic if there had either been a discovery request for the Facebook page or some kind of court-sanctioned contact. The problem is they're having the paralegal go on that Facebook page under a false identity, although the lawyers later claimed they did not know that she created a false identity, which of course creates supervisory issues for the lawyers. And two, she was contacting a represented party without permission of the party's lawyer. Actually that case is in complete New Jersey, but the rules implicated by that kind of contact are truthfulness in statements to others. So you see these rules being implicated in the context of social media. You can't fail to disclose the material fact when disclosure is necessary to avoid assisting in criminal or fraudulent activity, and you cannot contact someone represented by counsel without the permission of that person's lawyer. And the rule is very specific. The only one that can waive the contact rule is the lawyer for the party. Why? It's to prevent overreaching, and there's a lot of cases that say even if the client says, oh, well, I'll talk to you, the lawyer cannot talk to the represented party without permission of the other lawyer. So remember, it doesn't change just because you're on social media.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.